Real people, real cases. This is Verdict Watch.
Right on top.
Oh, thank you. Okay, let's go on the record in the matter of the state of Michigan versus Nicholas Matthysse, 24668. And counsel, your appearance, please.
Good afternoon, Your Honor, and your staff. Attorney Quentin Dox, plea number 79657. On behalf of my client, Mr. Nicholas Matthysse, this appears to be in Wayne County's jail and consents. Mr. Matthysse, please unmute and state your full name for the record.
Nicholas Matthysse.
All right, good morning, sir.
Good morning.
I'm sorry, good afternoon. Okay, counsel, today is the date scheduled for the probable cause conference.
Your Honor, we're going to ask for a preliminary exam.
Okay, and so we are going to set that for, I don't know, what day we set it? Next week? The 20th or 27th?
Your Honor, may we do the 27th?
Okay, does that work for us, Kelly?
I'm looking at it. Yes, but it has to be at 11 because you're blocked off after that.
Yeah?
Yeah,
All right.
it just says judge off 145 to 4 on 327.
Oh, I know, I have no, okay, we can do 11 a.m. on the 27th, counsel?
Yes, Your Honor, I do have something in Judge Gillis's in Third Circuit 11, but I can finagle and get that earlier. Yes.
Okay. And counsel, would you like to waive time with your client on the record, please?
Yes, Mr. Matthysse, I did explain to him earlier on that he had a right to a preliminary exam within 21 days of the arraignment. He has chosen to waive that right for good cause.
All right, court will note the time on record. Witness and exhibit list due by March 24th. Bond and conditions are continued, and we will see you back on the 27th.
Now, Your Honor, I do believe that his bond right now is at $20,000, 10%. Family is well prepared to pay that. They did pay that. Unfortunately, it was to a scammer. His dad paid $1,000 to somebody who ran away with the money. On light of that, and I try to make it a sob story, we're asking that a personal bond with a GPS tether or even house arrest. He has a valid address. He has ties to Detroit. He has a young daughter. Although he will not be able to work, if you grant him house arrest, he will at least be able to communicate with his young child and make preparations for this case.
Okay, well, unfortunately, counsel, there's another matter pending for your client. Ellen, can you pull up the 25284? Please.
Yes. Okay,
What is the bond on that one?
20,000 10%.
Okay, and what was the date of that offense?
March 2nd.
Okay, so counsel, here's the situation. Your client was set to be arraigned on September 12th of 2024 on the felony matter that you represent him on. He failed to appear for that, and on September 17th of 24, the court issued a $10,000 10% bond. Your client still did not contact the court, did not make any attempt to appear in court for that arraignment. The only reason he was arraigned on this matter is because he got arrested on another matter, which he's charged with CSC, 4th degree assault and battery and domestic violence. So there's also a $20,000 10% bond on that matter. So I'm not inclined to amend the bond in this felony matter based upon his prior failure to appear. And then he also has the other matter that's a $20,000 10% bond.
Roger that, Your Honor. I understand.
All right, bond and conditions are continued. We'll see you back on the 27th. Mr.
Yes.
Matthysse, you're not going to go anywhere because you still have to speak with your attorney, Mr. Gopal, on the misdemeanor matter. Okay. Thank you. Okay, and then where did
Next case on the docket.
the city of Wyandotte for Stephen Dinion, 241519.
Good afternoon, Your Honor. Attorney Thomas Court, P77177, appearing on behalf of the defendant who stands to my right. Please state your name for the record.
All right, good morning, or good afternoon. Today's date is scheduled for sentencing on your plea to an amended charge of trespass. The charge of larceny was dismissed. Is Cody Boon present? Probation did speak to Cody, and Cody has indicated he's not requesting restitution. I was just checking to see if Cody was present in the event that they wanted to address the court. And so, counsel, did you have an opportunity to review the report and recommendation with your client?
I have, Your Honor. We find it accurate, needing no additions or deletions.
Okay, the court will make that note. And as to the recommendation, I'm sorry, there's also a bond violation as well, just so we're on the same page of both. The bond violation, counsel, is alleging that your client did not submit the 20 job applications per week as ordered by this court as a condition of bond. So let's handle the bond violation first.
Fair enough, Your Honor. I didn't see the bond violation, but I'm prepared to proceed forward. I was going to tell the court, I think that that's obviously a cornerstone in a case, almost any case everybody should be employed. In my experience, and I don't mean to denigrate my client at all, I think that he may be cognitively impaired even though he denies it. He's been unemployed since 2022. An average grown man isn't unemployed for 3 years. He rides a bike to court. He was living with his parent until his father died recently. He's living in a home with no utilities, Your Honor. I don't think that at all he's doing that to be contemptuous of the court. I honestly think that no grown adult man would live with no utilities and no money and ride a bike if he didn't have some cognitive issues.
Well, counsel, I can appreciate that, but you'd be surprised with what I see in front of me on a regular basis. I would be surprised. So let me just ask you this, counsel. Did you receive a copy of the notice to appear? Regarding the bond violation, the bond hearing, it says bond hearing down here.
You know what, I apologize, Your Honor, it might have came, so I'm not gonna say I didn't, but I'm prepared.
Just so you know, it specified what the bond violation was up here.
I apologize, Your Honor, I might have seen it.
Okay, I just wanted to make sure because it shows that it was sent out to you March 11th
Okay.
of 25. Oh, that was just 2 days ago. It would have been sent to you via email.
Oh, you know what, I probably just did glance, if it was an email, I probably didn't glance, but I'm prepared to proceed, I'm prepared to proceed.
Okay, so is your client pleading guilty to that bond violation?
Yes, Your Honor.
Okay, sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, ma'am.
Okay. Many people call me sir, apparently my hair might be confusing, I don't know. Okay, and so, sir, you heard the plea to you heard the allegation regarding your bond violation.
Yes.
As to the allegation that you did not complete the 20 job applications per week as ordered by this court at arraignment, how do you plead?
Good.
Okay. You've gone over you understand that you do have the right to have a contested hearing in this matter, and by entering into a plea, you will not have that hearing.
Agreed.
And do you understand the possible penalty as a result of your plea?
Yes, I do.
Knowing all of that, do you want to continue with your plea?
Yes, I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Okay. Counsel, can you please pardon your client as to the bond violation?
Thank you, Your Honor. Sir, you were aware that this court ordered you to fill out 20 job applications,
Yeah,
correct?
I did. When I went to show Marcy on my phone was dead, and I had the screenshots from the applications that I sent in.
Okay, when was that?
As soon as I left court, I applied online.
Okay, so when did you come in and show Ms. Shine those,
Well, the thing was when I came to probate, they're on my phone right now, I can show them to you, no problem. Where it says you applied, here's the record of your application.
okay, so you have those for every week from?
Every week,
Yes,
I
I said 20 job applications per week, and that was back on January 30th.
thought it was 20 applications in it a week. I'm sorry if I misunderstood.
In a week, every week.
Oh, I thought it was just for a week.
Oh, no.
Oh, I'm
No,
mistaken.
it's to help you,
I understand.
obtain employment.
That's my mistake.
Okay, so when did you, so you've indicated that you came in to show Ms. Shine. What date did you do that?
The day in which that
That you did your interview?
yeah, that day. I can't remember the exact date.
Okay, that's fine. Okay, so, but, the order was for 20 job applications per week.
Yes. I won't make any excuses. I totally did,
Okay, you
misunderstood.
received a copy of this order, correct?
Yeah, I believe.
Your bond conditions?
Yeah.
Where it says submit 20 job applications / week, that's per week.
Oh, see, I misunderstood it when I read it. I just thought 20 in a week. Okay.
Okay. So, of any of those 20, so here's what I'm going to do. So, I'm gonna find your client guilty for the bond violation, but I'm not going to send him to jail for the bond violation, counsel.
Thank you.
Thank you, Your Honor.
Okay, so from those applications, have you heard anything back from anybody?
Yes, actually, I have a cousin in Arizona who she, in her church group, she said that she has a friend who said she'll give me a job, no problem. All I gotta do is show up to the interview.
In Arizona?
In Arizona, yes. And I just got contacted for a job for Dollar General here, but that's minimum wage, and the job in Arizona pays a lot more than minimum wage here,
Okay.
because it's like $22
So are you
an hour.
planning to go to Arizona?
Yes, I am,
And when are you
because
planning to leave?
as soon as possible, as soon as I can get this tether off.
Well,
I have no family here. That my cousin in Arizona, my cousin Pam, that's the only family I have that even, that I talk to, that even cares about me, anything, and she wants to help out. So I said, okay, let's go, I'm willing to come down.
okay, well, so when is it that, so here's what I'm thinking, here's the thought that's going through my head, counsel. If your client has a ticket purchase form and he's leaving the state and he's going to Arizona, one-way tickets, and he's gonna be staying there, then I would probably do something different with the sentencing than what's recommended. So do you want to adjourn this until he has that ticket purchased?
Yeah.
When are you expecting to purchase the ticket, sir?
She's gonna buy it for me,
Okay,
and then after I start working, I'm gonna pay her back
okay, so when are you expecting that would happen?
as soon as I get the tether off and I tell her it's off, and then
Okay,
she'll.
well, let me just say this, I'm not gonna take the tether off until I know that you're getting on the plane to go to Arizona. So if you want to
I can make
communicate
a
with
phone
her to
call.
let her know if she,
Yeah, sure.
for one day next week or something, or in a
I
couple?
can have her, I can get the ticket I can get it tomorrow.
You wanna
I can have her send me the money and I can get the ticket tomorrow, no problem. And then be on the next flight out.
So she's sending you the money or she's
She's
purchasing the ticket?
she's sending me the money.
Oh, I think she wanna just purchase the ticket for you, but,
I don't know. I can ask her,
Well,
I can call her as soon as I get out of here.
okay, why don't you do that, and then we'll recall it there, and then we have a little bit more of an idea where we're gonna move this to, okay,
Okay.
counsel?
Thank you.
Okay.
Yeah, I can call her right now.
We will recall the matter of Stephen Dingman. 241519B.
Hello again, Your Honor. Attorney Thomas Courts appearing on behalf of the defendant. Can you state your name, please?
Stephen Digger.
I'm sorry?
Stephen Digger.
Okay, very good, thank you. All right, and
Been better.
okay, what did you find out, sir?
Oh, I can get the ticket purchased tomorrow, no problem. And what do I do? Just come up here with the ticket and who do I show it? Would I see Marcy, show it to her? Do I email a picture or a receipt, or how does that?
Well, so let me ask you this, so you're purchasing the ticket tomorrow, when are you intending to leave?
As soon as possible.
Okay,
Whenever they tell me the next flight, if they said the next flight's tomorrow morning, then it's tomorrow morning, then I'll be leaving on that flight.
okay. Well, so counsel, what I'm inclined to do is if your client's leaving for Arizona, moving to Arizona, then then the plan will be then to terminate the GPS tether and find the cost and he can be on his way. But what I am not inclined to do is do that right now, not knowing that he's leaving for Arizona. So what we could do, sir, I presume you might need some time to pack your belongings. Do you have many belongings?
No.
Okay. Here's what I'm going to do. I'm going to kind of do two sentencings. In the event you purchase a ticket and you're leaving tomorrow, this court's going to send it to you to fines and costs.
Okay.
Okay? Because you're going to be moving to Arizona for work, you're going to be completely relocating there, you're not going to be here any further. And then the court's going to assess fines and costs, which I'm going to do in just a moment.
Okay.
In the event you do not leave for Arizona tomorrow or even.
It would be as soon as possible.
Right, then the court's going to adopt the recommendation of probation.
Okay.
Okay, so let's do this. You purchase the ticket tomorrow. If you'd like to come up here, you can certainly bring it up here, and then, actually, that probably would be best, if you bring it up here, and then that way we will,
You can make a copy or whatever you got.
that's fine, but we'll also do, we'll have a written order counsel, so then that way it'll be one way or the other. Path A or path B,
All right.
okay, I know this is very unconventional, but this way you don't have to all come back for a sentencing, okay, and then counsel, what we'll do is then we'll send you an email as well.
Yes, sir.
Okay, I'm gonna do you a huge favor, sir. In the event you're leaving for Arizona within the next couple of days, I'm just going to pay your fines and costs as well.
Okay. Thank you, Your Honor.
You're not working right now, and you're relocating, and then you're just gonna start anew over there, and there isn't any restitution that's been requested. So that's where we're at right now, okay? So it's A or B. And then what we'll do then, counsel, is if you're comfortable with it, depending on what your client presents tomorrow, you'll get communication, whether it's A or B, whichever one.
That'd
okay?
be perfect, thank you very much.
And if it's not, if it's B and you're going to be remaining in the state, in the area, then then there will be fines and costs assessed because you're gonna be taking a job,
Right.
okay?
That'll definitely be it.
Okay,
Thank
good
you.
luck to you,
All
sir.
right. Thank you.
You're welcome. All right, let's go off the record.
Next case on the docket.
Is your client at the office with you?
Yes, yes, Your Honor.
Okay, you guys can just be on the same screen if you'd like.
That's all right. I got him set up in my office with the computer.
Okay, so Mr. Boynton, please remove your hat. Thank you. Okay, so let's recall the matter of the state of Michigan versus Bram Boynton, 25160.
Again, may it please this honorable court, Gerard Scanlon, P number 74992, appearing on behalf of Mr. Boynton. Good afternoon, Your Honor.
Thank you, Mr. Boynton. Your name for the record, please.
Robin Louis Boynton, a second.
Thank you. I appreciate you both standing for court. Thank you very much. And you can sit down now, sir, if you'd like.
Thank you.
No, you can sit down as well if you'd like.
Thank you, Your Honor.
Okay, today's date scheduled for the arraignment and pretrial in this matter, and as to the arraignment.
As to the arraignment, wait for my reading, stand mute.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment as to the pretrial counsel.
Pre-trial, Your Honor, I've had an opportunity to meet and speak with the prosecutor in this matter, and I've advised the prosecutor of the circumstances surrounding the reason why the charges came about. At this time, I'm going to write a letter to Gary Bresnahan because according to the prosecutor, unfortunately, he's not able to offer me a reduced plea. And so I'm going to plea for leniency with Mr. Bresnahan, but I have to write that letter to him. Thus, I'm respectfully requesting an adjournment of the matter.
Okay, we can adjourn this to, does March 27th work, counsel?
Let me take a look real quick, Your Honor. What time?
10:15.
10:15?
And is that via Zoom, Your Honor?
No, that's in person. This is actually in person too, so I'm not really sure why you're both on Zoom.
Can you give me another date, Your Honor?
The 20th? We can go 1 or 2 weeks.
I can do the 27th. I'll just have to make it work.
Okay, but I'm confused as to why you're both on Zoom today, counsel.
Your Honor, my client had recently retained me, and unfortunately, I did not realize that this was in person, so that's my fault.
Okay, so let me just clarify, counsel. Other than a probable cause conference or landlord-tenant matter, everything's in person.
Okay, thank you.
Okay? All right, so we'll do 10:15 a.m. As to bond counsel.
As to bond, Your Honor, my client's not a flight risk. He has appeared voluntarily in this court. He's never absconded from the jurisdiction, and I believe that he is gainfully employed, and thus I would request a personal bond.
Sir, where do you work?
Thermo Fisher Scientific, downtown Detroit. Pharmaceutical laboratory.
How long have you worked there, sir?
20 years in June. June 24th to be exact.
If you were to test today, sir, what is in your system?
Nothing.
Sir, how do you get back and forth to work?
I drive. I have to drive.
Okay, but you don't have a valid license, do you?
No, I do not.
Then you can't drive.
Right. I thought you were saying in general, how do I get back and forth to work?
I did, and you said you drive, and you're not allowed to drive.
Right.
So, how do you think that works, sir?
I have no idea.
So I'm going to guess that you drove to your attorney's office.
No,
How did you get to your attorney's office?
I got dropped off.
Okay. Sir, make sure you're not driving. You don't have a valid license. Why is your license not valid?
Because of this DUI mess.
This one?
Yes.
Oh, was there a, oh, there was implied consent. Okay, that's fine. Okay, well, sir, you're not allowed to drive. The court's going to order a $7,500 personal bond. You're not to possess or consume any alcohol or drugs that are not prescribed, and no driving, sir, unless you're cleared by the Secretary of State.
Excuse me if I may speak.
Okay?
How am I supposed to get back and forth to work? Can I have a restricted license or?
That's something that you're going to have to request from the Secretary of State. Your attorney can help you with that. But sir, because your license is suspended, you need to make alternate arrangements to get back and forth to work.
If I may, Your Honor, I just lost my son. I have no one to help me, no one. I just lost my son August 7th of this year.
All right, and the court does extend its condolences, sir. And I understand that it's difficult, but you may have to hire someone to drive you, you may have to utilize rideshare services, the bus, I'm not sure, but you're not allowed to drive. And when I tell you that you're not allowed to drive, it's for your own benefit, sir, because if you get pulled over, then that's another criminal charge, driving while license suspended. And then it's just going to be a downward spiral with that. So right now, I believe your implied consent suspension is over. When is it over, counsel? Is it 6 months? So I believe, let me see, so that went into effect.
It's actually a year,
Oh,
because
so it's until December 6th of 25.
they got me down as refusing a breathalyzer, but I didn't. I have asthma, so they wasn't satisfied with the way that I was blowing.
Okay, so then, sir, you're gonna have to chat with your attorney. I don't know if he's filing an appeal on that. I don't know if he's going to file something with the Secretary of State, but until you hear something different from the Secretary of State, I'm letting you know you cannot legally drive a vehicle.
There's nothing I can say or do, Miss, Your Honor.
We'll see you back on March 27th.
Okay, thank you very much.
Thank you, and have a good day.
Thank you, Your Honor. You
You
too.
too.
Next case on the docket.
On the record matter of Zachary Laz, 241619.
Your Honor, John Goldport, P 30758 on behalf of Mr. Lazat. Mr. Lazat, would you please put your name on the record?
Your Honor, my name is Zachary Stephen Laz.
Okay, so Mr. Leza, you are currently on probation. The court sentenced you February 3rd. And that's on your plea to domestic violence, aggravated. This court sentenced you, sir, to this is a bond violation, not a probation violation, let me clarify.
That's correct, Your Honor.
Bond violation. This court ordered you on November 12th to not possess or consume any alcohol or drugs unless prescribed. And it's tested positive, it's allegedly tested positive for January 26th, which was reconfirmed, as well as additional results from another test that you were ordered to participate, or you were ordered to take through the 33rd District Court probation color.
Yes, sir. I sent the results out a second time to reconfirm because I've been dealing with this with 33rd. I'm on a variety of medication, SSRIs, things of that nature. I've had several initial positive drug tests that ended up coming back negative after the fact. I would like to attest that this drug test is also not, but I've had it sent out twice.
They've all been reconfirmed.
Yes, I understand that, Your Honor. I just don't.
Do you have something from your pharmacist, something from your doctor that says that any of your prescribed medications that you take will show up positive for benzoylecgonine?
I don't have that information on me. If you'd like to adjourn.
No, sir, let me just say this, okay? This is something that you've been apparently dealing with since the end of January. Because that was when you have a test that shows positive for cocaine.
Yes.
Now there's another one. So I would presume.
I'm sorry, a second one?
Well,
There's not.
it says here, hold on, I just said, you're on probation with the 33rd. The probation officer also shared that there was a positive result. And Ms. Shaw was awaiting confirmation, the confirmed test, and then you also told Ms. Shaw that those two were positive. So my point is this, you're alleging that this is an issue with your medication. So no, and now that's been twice that you have these two positive tests.
That's right.
Which is interesting that you don't have them for all the testing. However, you should have brought with you something from your doctor or your pharmacist that would indicate what potential medications that you're currently prescribed would test positive for benzoylecgonine. Which I don't know if I'm even pronouncing that correctly. You don't have that here. Why not?
I I guess the only thing I can think of is negligence. I guess we should have thought further on.
Well, right, so now I'm concerned here, sir, that you are using cocaine. Because now you have 2 positive tests, you take the same medication.
Yep.
Sometimes the tests are positive, sometimes they're not. So that would tell me, just based on common sense, that it's not a result of the prescription that you're prescribed. Because you take that prescription on a regular basis.
You're on.
I guess you're gonna tell me you don't do that.
No. What I was gonna inform you, it's I have tested positive for fentanyl, benzodiazepine, just a plethora of substances. So and all of those became negative. I don't have an excuse, Your Honor. I haven't knowingly or willingly used any cocaine well beyond the amount of time that, for instance, I've used alcohol. So I don't have an explanation. I'm going to plead guilty today to move things along because I know that if nothing good is going to come of me just coming in here and sitting in front of you again.
Well, sir, you have the right to have a hearing. Mr. Gopal just had one yesterday for a probation violation hearing. So you have the right to have a hearing.
Do you have advice, sir?
So,
Do you have any advice on the matter in regards?
Well, sir, I spoke to you. You indicated that you did not knowingly take anything that had cocaine in it. You indicated to me that you were at a particular event a couple of days before this and may have been come in contact with some individuals, but my advice is if you're not guilty of intentionally taking the cocaine or the prescribed substance, then you have a right to a hearing as the court indicated.
Your Honor, I looked at a non-guilty plea until I can, I guess, have a better grasp on what it is that the court is, what action the court is going to take against me.
Your Honor,
I can't tell you what everybody's.
I
Here's what I am going to
completely
do.
understand.
I'm going to enter a plea of not guilty,
Okay,
and we'll schedule this matter for a hearing.
okay, thank you, Your Honor.
Bring back information from your doctor that indicates which of those medications would be testing positive for cocaine
Okay, thank you, Your Honor.
or benzoylecgonine, the cocaine metabolite. Would you like the lab present, counsel?
pardon, Your Honor?
Would you like the lab present?
I believe that would be necessary, Your Honor.
So let's set this for April 3rd. Yeah, maybe like 11 a.m. maybe? Okay, 11 a.m.
April 3rd at 11 a.m., Your Honor?
Yes.
Okay, thank you.
Okay, thank you. Have a good day.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.